kick off, it's important to note that the Commission, and I'm going to speak to the protection mandate and executing the protection mandate for the Commission, we are responsible for, in essence, investigating complaints, right? Now, one of the first questions that I always get asked, what is a complaint at the Human Rights Commission? What constitutes a complaint? It's important to note for our purposes, it's not only a violation of a human right, but it's also a threat of a violation of a human right. So whenever anybody feels as though their rights are going to be violated, you don't have to wait for your rights to be violated before you come to the Commission, but if you feel that there's going to be even a threat of a violation, you have the opportunity to come to the Human Rights Commission and you'll come and lodge a complaint with us. Now, I would like to also emphasize, and this is a very important point, that not only do you have to be a complainant to lodge a complaint, if the Commission happens to read in the newspaper, happens to be informed by another stakeholder that there's a possible violation or a violation taking place, the Commission can, with its own volition, institute proceedings, right? You can open a file, an own initiative file, and not have to wait for someone to actually lodge a complaint with it. So these are very important issues to remember, because it also assists us in doing the work of the Commission. But at a more substantive level, and something which is legislatively prescribed, and you would understand why, if you reflect a bit on it, is that the Commission has as a first port of call always to consider whether it has the ability to conciliate, negotiate, or mediate a dispute. In undertaking that as one of its first tasks in trying to see whether it can adequately resolve a complaint, our role is to actually try and bring parties together. A lot of my colleagues mentioned our roles in litigating, in going to equality courts. When a court orders you to apologize, and there's no other avenue available to you because then you'll be in contempt of court, is it really bringing the parties together? Not really, right? But at least that is an avenue available to us should our other means, conciliation, negotiation, mediation, not be able to assist us in getting the parties together. So that's something that we also have the ability to do, and we always, maybe as a unwritten rule, is always try to make use of those means first to bring parties together. Having mentioned that, and so I'll anecdotally speak to this at a later stage, we can, though, institute proceedings before a court of law. Most of my colleagues mentioned equality, right? But I think they also, just to back it up a bit, there's a specific court that has actually been created in our country called the Equality Court, which is, I don't know whether I'm speaking to a room full of lawyers, and you will tell me if you all are, but how pedantic, how specific, how time-consuming, how costly litigation usually is, and not always available to everybody. Equality courts, however, have been created in such a way as to, number one, make them less bureaucratic, less formalistic, but at the same time try to speed up the process of being able to assist people who want to lodge those kinds of complaints. In terms of PAPUDA, my colleague mentioned that act, right? The Commission is it's even prescribed, in fact, that the Commission must assist those complainants in bringing matters to court. So when we try and do our work, we also try to look at that avenue as a means by which we can seek and try and get appropriate redress. Having said that, and looking very fondly over at my colleague who's mentioning to me that I must now hurry up, I can reflect a bit on the work that we do as the Legal Services Unit. And in receiving complaints, and one of the avenues available to us would be, if we accept that as a complaint, would be to produce investigative reports. I have a colleague of mine sitting way at the back over there who at any moment will smile fondly, who is working at a provincial office, who will know how much work it takes in order to get a matter to the point of being able to produce an investigative report. An investigative report is a report that the Commission, our provincial officers will prepare, which will have findings and recommendations in it against a respondent, right? Usually signed off by a commissioner, should be signed off by a commissioner, right? And once sent to the parties is the means by which we get a matter and try to finalize a matter to say, well, listen, the Commission has now made its findings, it's made its recommendations, we're going to communicate that to the parties. Unfortunately, they're not executable. It's not a court order, we can't force people to comply. But what it does do, however, it does put us in a position to say we finalize the matter for our purposes. If you do not choose to comply, other avenues are available. It's the more adversarial course of action, the proceeding to go to a court of law. And I mean, that avenue is always available to us, but that is one of the means by which we can actually finalize a matter. Another means that we make use of, and I've sort of mentioned before, is alternative dispute resolution. We mentioned negotiation, conciliation, and mediation. And a lot of our colleagues have now been trained, in fact, have been accredited mediators. So we're capacitating our colleagues to be in a position to be able to mediate disputes a lot more adequately than we may have in the past. And we're seeing that statistically that's reflecting in our work, and actually maybe it's making a bit of a difference in terms of how we finalize and resolve disputes. And I've mentioned litigation, and litigation is obviously one of the courses of action we can pursue. Again, very time consuming, very costly, but is one of the avenues. We have a specific responsibility at head office to consider strategic impact litigation, and that's when matters become more systemic in nature, and that's one of the avenues we do pursue. Now, anecdotally, and just to give a little bit more life to this very bland and boring presentation, right? I can mention already, yesterday we were in the High Court in Pretoria, not too far from here, right? We were actually pursuing a matter where members of the community were unlawfully evicted, right? And I need to mention this, in 2013, right? So it has taken such a long period of time actually for us to get to the court, and it was challenging. I'm actually quite hopeful judgment will be handed down on Wednesday, so we're eagerly awaiting it, the judgment. We think it's going to go on our way, but you can see how in trying to assist a group of complainants who were unlawfully evicted, how long it's, number one, taken us to get to court, and number two, hopefully will get us the appropriate redress that we want to secure. Now that's yesterday. In about a week's time, and in fact one of the commissioners who's here today is actually going to be sitting on a panel, we're going to be hosting a hearing on the impact of protest action on basic education. Now this is one of the other means that we can make use of as the Legal Services Unit. It was motivated to us, conceptualized, that there's a bit of a systemic issue that we needed to ventilate. It cannot be done by an individual complaint basis. There's quite a number of complaints that maybe this has been brought to the fore. And what we can make use of is an opportunity to host a public hearing, inviting quite a number of state respondents, other parties, other stakeholders, and ask them to answer certain questions, address us on certain issues, and like with investigative reports, produce a report which has findings and recommendations. It's usually the means that we make use of when it's quite systemic in nature, not an individual, only an individual is impacted, but rather a community, a bigger, broader selection of community, not only in a province, but maybe nationally, and has also in the past been of great benefit to us in terms of escalating a matter and ventilating a matter where we can try and use Gail and her colleagues' ability to get communications and media involved to get a little bit more of a message out there. My other colleagues have spoken a little bit about the work that we also do in the provincial offices. Joyce has spoken about the law clinics and investigating complaints at that level. But I'm now going to defer to Gail and her, I don't know, whatever you described, the looks that she was getting, I'm now also getting.